This AI-generated podcast is for general information only and does not constitute financial or legal advice. Please consult a qualified professional. Welcome to the Luxembourg Fundcast, produced by Bertrand Mariaux, a regulatory lawyer qualified as Avocat à la Cour in Luxembourg and Paris. This show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 25 May 2026. So, let us transition immediately into the core mechanics of the Luxembourg cross-border private banking perimeter.
Right, and to frame this, we need to look at the CSSF's private banking subsector risk assessment for 2023. It reviews that around 80% of Luxembourg private banking clients actually have their fiscal residence outside the country.
Exactly. 80% are non-resident. So serving this global base from a single European hub requires a strict internal legal map. You have to clearly distinguish permissions based on client residence and the specific service type.
Yeah, you really do, because when the vast majority of your clients are non-resident, the primary statutory objective becomes, clean home host supervision.
Right.
Cross-border private banking is never just a single blanket permission. It is a highly controlled service perimeter that completely shifts depending on where your client sits.
So let us examine the actual geographic mechanics that dictate that market access, because the rules change dramatically depending on whether we are looking at a European economic area footprint versus a non-EEA footprint.
Precisely. The baseline is entirely different.
Right. So within the EEA, we always hear about passporting routes. But mechanically, under Article 34 of the 1993 law, how does that work for first-time service provision? Can an institution just send a quick notification to the local regulator and start operating?
No, the statutory text takes a much more deliberate approach. Under Article 34, a Luxembourg credit institution or investment firm cannot directly contact the host regulator.
Wait, really? They don't talk to the host authority directly?
Exactly. They must communicate their intended services directly to the CSSF. And then the CSSF takes on the responsibility of forwarding that notification to the host authority. So it's a formalized dialogue between regulators.
That formalized dialogue implies a timeline, though. Like if a relationship manager spots an opportunity and wants to adapt their services in another member state, how quickly can the firm pivot?
Well, you cannot dynamically alter your service provision on a whim. The critical detail in Article 34 is the notification period. Any changes require written notice to the CSSF at least 1 month in advance.
1 month, right.
Yeah.
So that gives the regulatory apparatus time to assess the new perimeter.
Exactly. Operating legally requires strict adherence to those advance notice periods.
But what happens when we look at the operational reality outside of the European Economic Area? Because once you leave the EEA, that passporting mechanism and that CSSF notification channel just cease to exist, right?
Yeah, that absence changes the baseline entirely. Outside the EEA, there is no European passport. This requires strict country-by-country checks.
Meaning you have to independently establish the local access parameters for every target jurisdiction.
Precisely. You must physically map out local licensing requirements and marketing restrictions. The firm has to know the exact local law before initiating contact.
So we have mapped out the geographical borders, whether through EEA notifications or non-EEA local checks. But a border on a map doesn't mean much if the actual relationship managers don't respect it.
No, it doesn't. And that brings us directly to Chapter 4 of the 1993 law.
Right, exactly. How do legal and compliance teams practically anchor these geographic constraints into the firm's internal governance?
Well, Chapter 4 provides the framework. Specifically, Article 37-1 governs organizational requirements and product governance. Mechanically, this dictates that every single financial product must have an identified target market.
And a clearly defined distribution strategy, right?
Exactly. So the target market cannot simply be defined by client wealth or risk appetite. It must explicitly include geographic eligibility.
Let us test that mechanism. Say a firm designs a new alternative investment fund. If their non-EEA country check restricts active marketing in a specific jurisdiction, how does Article 37-1 enforce that?
The Product Approval Committee has to hard-code that restriction directly into the distribution strategy. If a local jurisdiction prohibits marketing that fund to retail clients, the internal governance framework must prevent the product from ever reaching a restricted client profile.
That makes sense. But I want to push back slightly based on Article 37-3, which mandates acting in the client's best interest.
Okay.
What if a relationship manager finds a product that perfectly aligns with a client's financial goals and yields a massive return? Some might argue it is in the client's best interest to offer it, regardless of jurisdictional borders.
Well, no, that is a common operational misunderstanding. Under Article 37.3, institutions must act honestly, fairly, and professionally in the client's best interest.
Right, but doesn't professionally just mean giving good financial advice?
From a statutory perspective, acting professionally inherently means operating strictly within the legal permissions of the client's home jurisdiction. A legally restricted product introduces unacceptable regulatory risk, so offering it is never in their best interest.
That statutory definition actively dictates the boundary between active marketing and execution-only activity, then.
Precisely. The legal perimeter must dictate that active marketing triggers the full weight of the product distribution strategy. Receiving an execution-only order operates under a completely different statutory categorization.
Moving from statutory requirements to daily practice, we often see sales teams look for mechanisms to simplify these cross-border interactions, specifically reverse solicitation.
Right, the concept of client initiative.
Yeah. Can institutions systematically rely on reverse solicitation as a standard legal mechanism for outbound servicing into restricted jurisdictions? Like if the client calls first?
The definitive answer to that is no. Reverse solicitation must be treated strictly as a host country and product-specific question.
It is not a standard outbound distribution strategy.
Absolutely not. The evidentiary burden required to prove the service was provided at the exclusive initiative of the client is exceptionally high.
To illustrate just how high that discipline is, let's look at Luxembourg's inbound framework.
Yeah.
How does Article 32(1) of the 1993 law handle this for third country firms targeting Luxembourg?
Article 32(1) is rigorous. If a third country firm drops even a subtle marketing breadcrumb, say, a targeted advertisement or an unprompted email that reaches a Luxembourg resident, the reverse solicitation defense is completely invalidated.
Wow, so prior marketing totally destroys the defense.
Yeah.
But the crucial point here is that a Luxembourg institution cannot use its own Article 32(1) as the legal basis for outbound servicing.
Exactly. You cannot export your home state standard. If you are dealing with a client in a non-EEA country, that host country's local regulator will apply its own tests, which might be even stricter.
So if reverse solicitation is off the table, how does the onboarding process physically reflect these geographic constraints? It sounds like it could become an unmanageable web.
The operational reality is that onboarding must be explicitly split into specific service lines. The legal perimeter requires dividing the relationship into 3 items: investment services, banking and credit services, and custody arrangements.
Oh, so approval for custody arrangements does not automatically mean you are authorized to provide investment services.
Exactly. Each of those 3 lines requires its own validation against the jurisdictional perimeter.
And what is the standard compliance and legal execution process for tracking all of this?
It necessitates the implementation of a live country service matrix. This matrix actively aligns the advisory terms, the mandates, and the relationship manager instructions with the host country restrictions.
Right, and in practice, that matrix provides the definitive internal control record. It generates the approval trail to prove why a client could be legally contacted and exactly what service was provided.
Precisely. And while securing external local law counsel is required, maintaining this matrix is not some massive burden. It is simply a standard compliance and legal execution process necessary to preserve jurisdictional credibility.
That makes total sense. Now, because this operational matrix is a live tool, it must be continuously updated to reflect upcoming fixed legislative milestones.
Right. You cannot rely on outdated analysis.
Exactly. So looking at the regulatory radar, what are the specific fixed dates practitioners need to code into these compliance matrices right now, particularly for third country branch regimes?
Well, the market focus remains purely on execution today. There have been no structural shifts in the last 48 hours. However, the critical framework driving updates is Directive EU 2024-15/19, which is commonly known as CRD6.
Right, CRD6, which amends Directive 2036 EU. Mechanically, what is the fixed timeline for this?
The timeline is already in motion. Articles 3214 and 3215 of the 1993 law already apply from the 11th of January 2026.
Okay, so that is already in force. But what about the specific perimeter work for third country branches touching Luxembourg? What is the legacy grandfathering cutoff?
For legacy third country arrangements, the grandfathering cutoff is the 11th of July 2026.
So if an institution fails to adapt its matrix by the 11th of July 2026, they lose those transitional protections entirely.
Exactly. Because following that legacy cutoff, the third country branch regime generally applies from the 11th of January 2027. So those specific dates must be structurally embedded into review cycles right now.
This timeline really underscores the core reality we've examined today. A static legal memo left in a drawer is completely insufficient for modern cross-border private banking.
It truly is. The host country parameters constantly evolve.
Right. The ultimate operational answer and the foundation of institutional credibility is the meticulous real-time execution of the live country service matrix.
Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mariaux and Rigor Media on YouTube. Connect with Bertrand on LinkedIn at bertrandmariaux.com. All links in the show notes. This was the Luxembourg Fundcast.
Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mariaux and Rigor Media on YouTube. Connect with Bertrand on LinkedIn at bertrandmariaux.com. All links in the show notes. This was the Luxembourg Fundcast.